An accomplice is a person who has knowingly participated in the commission of a crime either as a principal offender, helper, conspirator or abettor. Since an accomplice is involved in the offense, he has direct knowledge of how the crime was committed. Therefore, the law permits an accomplice to give evidence in court. However, because such a person may try to save himself or shift the blame to others, the court examines his evidence with great care under the Bharatiya Saksha Adhiniyam 2023. Similar to the earlier Indian Evidence Act 1872, an accomplice is a competent witness, and a conviction is not illegal merely because it is based on the uncorroborated testimony of an accomplice. At the same time, courts generally follow the rule of prudence that an accomplice's evidence should be supported by independent evidence. 1. Who is an accomplice? An accomplice is a person who intentionally joins another in committing an offense. An accomplice may be the main offender. A person who helps in committing the crime. A conspirator who plans the offense. An abettor who encourages or assists the offender. 2. Is an accomplice a competent witness? Yes. The law treats an accomplice as a competent witness because he has first-hand knowledge of the offense. However, the court does not blindly accept his testimony because he may want to save himself from punishment. He may falsely implicate others. He may expect pardon or some personal benefit. Therefore, the court carefully checks whether his statement appears truthful and reliable. 3. Can a court convict solely on the statement of an accomplice? Legally, yes. Practically, courts exercise great caution. The law provides that a conviction is not illegal merely because it proceeds on the uncorroborated testimony of an accomplice. This means there is no legal prohibition against convicting solely on such evidence. However, the long-established rule of prudence is that the court should ordinarily look for corroboration, that is, independent evidence. Thus, rule of law, conviction based only on accomplice evidence is legally valid. Rule of prudence, courts normally seek independent confirmation before relying upon it. 4. What is corroboration? Corroboration means independent evidence which confirms the important parts of the accomplice's testimony and connects the accused with the offense. The corroboration need not prove every small detail, but it should support the material facts showing the involvement of the accused. Example, if the accomplice says that stolen jewelry was hidden in the accused's house and the police recover it from there, the recovery acts as corroboration. 5. Why is corroboration preferred? Courts insist on corroboration because an accomplice is himself a guilty person. He may lie to obtain pardon. He may exaggerate facts. It reduces the risk of convicting an innocent person. It increases the reliability of criminal trials. Case study, Rameshwar v. State of Rajasthan, 1952. Although this case mainly dealt with corroboration of evidence, the Supreme Court explained an important principle applicable to accomplice evidence also. The court held that there is a difference between a rule of law and a rule of prudence. Where the law does not make corroboration compulsory, courts may still insist upon it as a matter of caution before convicting a person. Simple understanding, the law allows conviction even without corroboration in appropriate cases, but judges usually prefer supporting evidence to avoid mistakes. Conclusion. An accomplice is a participant in the commission of an offense and is a competent witness under the Bharatiya Saksha Adhiniyam 2023. A conviction based solely on the testimony of an accomplice is legally valid. However, courts generally follow the rule of prudence and seek independent corroboration before convicting an accused. This approach balances the need to punish offenders with the duty to protect innocent persons from wrongful conviction.